In Chapter 14, we learn about intellectual property, which are the fruits of one's mind. The first area that is touched upon is trademarks, which I think many people are familiar with. But the one part that I thought was interesting, that um, even the product packaging, the shape of a product or the product packaging may be a trademark. If it is non-functional. So that I thought was an area about trademarking that I had not heard of before. I think many of us are very familiar with, particular words, signs, pictures, especially for, stores, that type of thing. Maybe the Disney Mickey ears or the McDonald's arches. Those are all trademarked things for those particular companies. The chapter then goes into patents, which is another area I think that people are somewhat familiar with. I am a bit familiar with patents, as my husband works for a company, and as such, any ideas that he has as a designer are actually the product of the company, which is sort of an interesting area as far as business is concerned. Patents are not easy to get, and it takes, quite a bit of doing. And, I know this firsthand from my husband's experience. Unfortunately, his company does have a legal team whose responsibility is to take care of all of those applications and all of the paperwork that is required to obtain a patent. And then it talks about trade secrets, copyright information, and the fair use doctrine. I think that one of the areas that is becoming more and more of an area, I don't know if concern is really the right word, but in light of the digital age, I think that that is certainly an area of concern, or an area to address, are the copywriting of any digital related materials, and making sure that those are all handled in an appropriate manner. As we go into chapter 15, we learn about agency relations and the fiduciary relationship between persons, in which one acts on the behalf of and is subject to the control of the other. So primarily, I think we're most familiar with an employer-employee relationship, which is very much drawn out of the master-servant. So where the employer is, in charge, and the employee is to follow the directives of the employer, so subject to the control of the employer. There's a lot of information within this chapter that's very important to know what the duties are between both the principal and agent, and in reverse, the agent to the principal. There's information that is important to know about power of attorney, or the being an agent by implied authority or implied consent. So knowing that, as far as power of attorney goes, that it is possible for businesses to have power of attorney be either general or limited. So you might have somebody with the power of attorney over a specific area of the business, or you might have someone with the power of attorney over the entire business itself. So knowing what the relationships are and what the limitations or not of those particular relationships are is extremely important. As we read through some of the cases within that chapter, understanding the the relationships and how the situation where say the attorney is in an implied consent relationship with their um, client and thus can make decisions on the client's behalf. Um, so knowing exactly what uh, those areas are and what those relationships are is certainly very important to an individual, to a business. The chapter also talks about the various types of liability of disclosed, partially disclosed, and undisclosed principles. So again, realizing that, especially where third parties are involved, what the duties are of disclosing, sharing that information about third parties or not sharing that information about third parties. So, so you're sure that you're within the legal rights to do so, and what the legal repercussions are. So, in, for instance, an undisclosed principal situation where there is a party acting on behalf of that third party, um, both of those parties can be held responsible and liable for the decision making that is being done. The chapter also talks about tort liability. This is very important for business. It's very important for a business to understand what their potential liability is as far as the relationships with employer-employee. For instance, if an employee is doing something during the time that they are working and a situation happens, it is possible that the employer could be held liable for that particular situation. So generally, employers are not held liable for criminal behaviors, but also it's important to be sure that you are aware of what is happening with your employees, because say there was a situation that you knew about and you didn't do anything about it, then certainly you could be held liable for those situations. So making sure that you are aware of where there may be violations on the part of your employees. So that is certainly an important area to be aware of. And then regarding the termination of principal and agent relationships, knowing that it is under agreements, it is required that third parties be notified and given notice if that agreement is being, if there's a separation within that agreement. Under the operation of law, third parties are not required to be given notice, but there's specific examples of the most common areas granted for operation of law: death, insanity, bankruptcy of the principal party, impossibility of performance, or an outbreak of war. So those are probably fairly limited as far as breaking the principal and agent relationship. So knowing that all parties must be notified, third parties must be notified who have dealt with an agent if there is a separation. And then really understanding in our global environment what all of this means, what these relationships mean as far as principal agent and agency law. I think one of the most important things that I pulled out of that section was that managers should be knowledgeable about the exporting company, distributors, and sales agents that they contract with, and the rules that govern those agents in their own country, because rules in one country certainly may be different than rules in another country, especially in regards to the rules that we have in the United States. There are certainly various countries that have other rules that may not even mirror our legal system. So making sure that you are completely aware of the the laws and rules in the countries that you're dealing with, and um, not just relying on representatives in those countries to represent your company, to know that you are aware of what those rules are and how they may affect you.